Hi, everyone. Thank you for joining us today. I'm Marche, the webinar director here at Advice Chaser. Before we introduce our guests and get started, I do need to do a bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only. And I'm sorry, I was just checking to make sure I was sharing my screen. It looks like it's working fine. It cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting, are not endorsed by Advice Chaser. Please don't act on the information you hear today without consulting a qualified financial professional. Well, we're thrilled to bring you this educational presentation today. Attendees are muted, but we encourage you to ask questions using the chat box. The presenters will answer those queries during or after the webinar today as appropriate. And if you ask a question in the chat box and we don't have a chance to get to it, go ahead and leave your phone number as well. If we can't get to your questions, we'll make sure someone will reach out after today's event. We want this experience to be as educational as possible, so please don't hesitate to ask for clarification or expansion of the material. Well, I'd love to introduce you to today's moderator. David Eads is the founder of Vital Investment Management and holds the designation of Certified Financial Planning Professional. Since he was 8 years old, Dave has had an affection for investments, which started with a fourth grade stock picking project at his elementary school. Dave possesses extensive experience in tactical investment strategies, comprehensive financial planning, and tailored retirement planning. Having spent many years in the investment industry, he can devise unique strategies to manage his clients' investments and personal finances effectively. Dave works hard to create a mutually beneficial and long-term relationship with his clients and their families. Dave is in the northern Colorado area, but serves people throughout the country. And why don't you go ahead and say hello really quick, David?
Hello, everyone. Thanks for joining the webinar. I'll field questions here and send them along to Will as needed, and look forward to communicating with you. Thank you.
Thank you. And I'd love to introduce you to our presenter today. Will Byers is a native of northern Colorado, and his practice focuses on estate planning, elder law, special needs planning, and Medicaid VA issues. Will is licensed to practice in Colorado and has been accredited by the Department of Veterans Affairs to handle VA claims. Will is a member of the Colorado Bar Association, Elder Council, Wealth Council, the Larimer County Trust and Estate Section, and the Larimer, I don't know if I'm pronouncing it, Larimer, there we go, County Young Lawyers Association. His monthly columns on elder law issues can be found in the Larimer County and Weld County editions of 50 Plus magazine. Outside of the office, Will is an avid Colorado Avalanche fan who loves getting outdoors with his wife and son and their golden doodle. And Will, I'm going to go ahead and turn the time over to you, and we'll get started. I do want to remind our attendees to go ahead and put your questions in the chat. Will is perfectly happy to answer questions during the presentation, and Dave will be fielding those and making sure that they get to Will during our presentation. All right, here we go.
All right. Well, thank you, Marche, for the introduction, and thank you, Dave, for having me today. So we are going to be discussing estate planning in relatively broad terms. It's something that affects everybody, and a lot of people, they hear terms tossed around, but rarely does it get broken down as far as what's really involved on a person-to-person, a family-to-family basis. And so really what I'm hoping to do today is just to give you guys kind of a general overview of what lawyers, what financial professionals mean by estate planning and kind of what does it entail. And so in its broadest sense, really, estate planning is the whole process of deciding where you want your property to go and who you want involved in the administration of the property. A lot of times it can be kind of an afterthought as far as who's involved, but that's really something that we spend a whole lot of time addressing and working through with our clients. And so I really think of estate planning as kind of a two-part process. And so the first part is what most of you are probably familiar with, and that is, where do my assets go upon my passing? If you have a business interest, which child, which family member do you want to inherit that? Which family member do you want to receive, precious heirlooms that you've collected through your family? And then certainly financial assets such as brokerage accounts, retirement accounts, your house, certainly, that's always a big one. Where does that stuff go? And so really going back to that, there being two separate parts of it, I would say that, 1A is really, who does the property go to? 1B is who's involved in the administration of the property. And so what we mean by who do you want in the driver's seat, that kind of jumping ahead a little bit, there are really two vehicles to do estate planning through. One is a will, one is a trust. But either way, who's in the driver's seat is either going to be who's your personal representative, who's the individual who is handling the probate process, who's ensuring that your assets are accumulated and that they are distributed in the fashion that you are hoping to see done. So who's in the driver's seat can really pertain to a couple different things. And so it certainly applies at death when someone is gathering up your property and they're deciding, or not deciding, but they're implementing where it goes, who it goes to. But also in the case of incapacity, that is a situation that is often overlooked. And the reality of it is death is relatively clean cut to plan for. It's one of the very few black and white issues in the legal realm. And so really just as crucial importance as deciding what happens upon your death is also, who do you want involved in the case of incapacity? Given that we deal with a predominantly 60 plus grouping of clients, we spend probably a particularly heavy amount of time detailing not just who is going to be involved at death and what that looks like, but also who's going to step in and ensure that property taxes are paid if you're incapacitated. If mom goes into a nursing home, what's that going to look like? How are you going to obtain the assets necessary to, or access the assets necessary to pay for her care? These are the kind of things that we see come up really on a weekly basis, truthfully. And so without diving too much further into that, as we'll touch on that later on, I think a good next place to start is why you should be doing it. So there are, and this is something where I'll have to kind of hold myself back, because I could really dive into a rabbit hole for several hours on why you should do it. But the biggest reason is that your family is different. Your family is different from my family, which is different from Dave's family, which is different from Marche's family. And so really, if you are not engaging someone to walk you through the estate planning process, essentially what you are doing is you are leaving it up to the state in which you reside. And so whether it's Texas or Colorado for our purposes, or Wyoming, they all have statutory criteria that states if an individual dies without a will, which is known as intestate, what the process looks like, who's given priority as far as where the property goes, who's given priority as far as the direction and the administration and kind of the managerial responsibilities of the administration of the property. And so I could certainly give you oodles of horror stories about how this can play out, but it's kind of an ongoing joke with my partner that anytime somebody says they have a very simple set of circumstances, it's usually a red flag, because the one consistent thing that I find is that there is no consistent family. Everybody's family is completely different. And so I think a lot of my job is having the difficult conversations about who is best suited to a task. One common example would be if somebody has 3 children and a husband and wife are coming to me for estate planning. There is a natural tendency, a natural parental tendency to say, well, I want all of my kids involved. I mean, that just makes sense. I get it. I only have one son, so I don't have to deal with that yet. But it's certainly kind of a natural response to say, well, I want everybody to feel involved. And that's not an incorrect way to feel. I certainly understand where people are coming from with that. But I think where I try to counsel people is that you as the parent, you as the person involved in the estate planning, you as the spouse, even if kids aren't in the picture, you certainly know better than I will know, or your financial advisor would know, or really anybody would know what the family dynamic is. And so common example is somebody will put off doing estate planning because it's a simple situation with a husband and wife, and there are 2 kids, and they say, you know what, at the end of the day, I just want everything to go to my spouse, and then I want everything to go to my kids. Well, that could certainly play out based on the statutory rules that your state has. But one thing that I can guarantee will come into play is who's going to administer the estate. And there is a lot that goes into that, as far as who's paying the legal fees, who gets final say on how the property is distributed. Because of course, with your assets, if you've got real estate, if you've got brokerage accounts, very rarely is it going to be completely cut down the middle. And so if you leave it, you die without a will, and you have 2 kids who are essentially on equal legal footing, then what can often happen is it can exacerbate any underlying tensions that naturally exist in families. And so if you are in that scenario, then a lot of times it can be left up to the children to fight it out, and to say, well, Jimmy's the older son, and he thinks that he should be in charge of everything because he's a stock market guru. But then you have a daughter who is a nurse, and she's, very successful in her own right, and she thinks that she should be making the decisions about what's going on with mom's care. That is kind of a perfect storm of legal, there are going to be some lawyers chomping at the bit to get involved with that, because those are not easy questions to find an answer to if you haven't given any sort of guidance on who you want involved.
Hey, Will, we have a question here from the audience.
Sure.
Actually, a few. The first is, what does the word statutory mean?
So statutory is just the state law. So the Colorado state statutes, they have a probate section. And so a statute is really just their kind of their core of their law that says, this is what the priority is, this is where the property goes, so on and so forth. But good question.
And the other question was, what happens when you don't have a will or a trust? What happens to the estate then? I know you alluded to part of that, but is there a
Sure.
high level?
Yeah, that's a great question. So what happens, and this is something that a lot of the financial professionals who are listening to this will be familiar with, beneficiary designations. So many of you will be familiar with the concept of, having a beneficiary designation on a retirement account, or on a brokerage account, or on a checking account. So that is kind of a first priority as far as where your property goes. So if I have accounts with Dave and I list my wife as the beneficiary of my retirement account, that actually doesn't even enter into the picture as far as opening up a probate or administering a trust, because that's really a contract that I have with my financial professional, so Dave in this case, where we have it on record, and then Dave sees, okay, Alexandria Byers is the beneficiary of Will's account. And therefore, usually it would be either my wife reaching out to Dave or Dave reaching out to my wife. And then they kind of work through the particulars of how that property gets passed to her. So you can do that with a lot of different accounts, brokerage accounts, general investment accounts, retirement accounts, bank accounts. That's one way to deal with property, certainly. Now, if there is real estate, and this is pretty much the case kind of across the board nationwide, as far as I've found, real estate, just by its nature, if I pass away and my house is just in Will Byers' name, then there's going to have to be a probate matter opened if there's not a trust that is holding the property, because real estate is just a high enough value item that pretty much every state says, hey, if it's not dealt with through one of these mechanisms and it's just in this deceased individual's name, you have to open up a probate. So that could, really nobody has to do anything, but if they want access to the property and if they want that property to be distributed, then they would have to petition the court and essentially get the court's blessing to say, okay, you are the daughter of so-and-so, you have the right to sell the property, encumber the property, do whatever you want to. But so really it's not like anything magically happens if there isn't a will in place. It just kind of leaves, it's almost kind of like a legal purgatory, so to speak, because things just kind of sit there, not being dealt with. And so obviously, if you've got a $400,000 home and your kids are going, hey, we could certainly use, $200,000 each to pay for the kids' college, then they're going to have to open up a probate matter with the district court where you passed away.
Perfect. Thank you.
Mm-hmm. So what options are available? And this actually leads in perfectly. So as far as what can be done with real estate. So real estate, at least in Colorado, and as far as I know, this does apply in quite a few other states, there is a deed known as a beneficiary deed. So to give you an example, if I wanted to deal with my property and I said, you know what, I don't want to go the trust route, or I don't want to force my kids to open up a probate or force my beneficiaries to open up a probate, what I could do is I could file a beneficiary deed for my house. So what that would look like is, because I'm the owner of record on my home in Fort Collins, if I said, you know what, I want Dave Eads to receive this property upon my death, what I could do is I could create and sign a beneficiary deed, much like any closing documents with a house. You would just kind of have it signed and notarized. But this beneficiary deed says, upon my death, I want this person to receive my real estate. And so I would file that with the district clerk and recorder, who, gets they're kind of the final say, at least in Larimer County and in Northern Colorado, as far as who owns property. I could file that with them, and they would have it on record that, okay, upon Will's death, Dave Eads just needs to take a death certificate down to the clerk and recorder. And at that point, they would shift the title into Dave's name. So that's one way to deal with property that doesn't fall under a beneficiary designation or agreement. But typically, what I suggest as a starting point for everybody, really, regardless of where you are in this planning process, whether you have wills or trusts or you have nothing at all, I think it is always helpful to go to the places where you have assets, whether it is, your financial advisor, whether it's the people who handle your life insurance policies for your work, certainly your bank accounts, to go in and just ask them, hey, what's the current titling on any accounts that you are managing on my behalf? And then also, what, if any, are the beneficiary designations currently? Because as you can probably imagine, I have seen situations where this hasn't happened until way down the road. And all of a sudden, we've got an ex-spouse listed as a beneficiary of a life insurance policy or a retirement policy. So that is a very quick, very cost-effective way to just ensure that, at least for the time being, you can always fine tune things later on in the process. And this is something that, when Dave and I have mutual clients, it's great to be able to bounce ideas back and forth and say, hey, Dave, what are you seeing on your end as far as the Johnson family? Because that's a very crucial part of any estate plan, is what those beneficiary designations are and who they are listed under. One of the common things that I see is later in life, if you have a child, somebody gets into their 80s and they have a child that lives nearby, and they're getting more and more help as far as paying property taxes, paying their monthly bills. You get to a certain point in your life where you just rather not handle that paperwork. And so a lot of times I will see someone add a child as a co-owner of a bank account, for example. That, by its nature, is adding a new owner to a bank account. So even though you are doing something that makes complete sense as far as wanting your child to have access to these assets so that they can help you pay off, any outstanding expenses that you have just changed the very legal nature of the asset. And so if you are in the process of doing that and you're saying, hey, my daughter Stella, she's really helping me out pay the monthly bills, I'm going to go into Wells Fargo and I am going to get her added onto my account as a joint owner. That is something that, as much as I would hope the financial institution would have a conversation about what exactly is going on there, the reality of it is people often don't realize what exactly they're doing. And so if you add somebody onto your bank account, a daughter for this example, and then you pass away, that daughter is now the sole owner of the entire property in that account. So really just knowing the titling, knowing the beneficiary designations, knowing where things sit as far as your assets go. I even recommend checking the titling on your house occasionally, just to make sure that, I've had spouses who thought that they purchased it as joint owners with rights of survivorship. And for those of you who are unfamiliar, when you purchase something with rights of survivorship, it basically says, if I pass away and my spouse is still alive and they're on the deed, I want them to receive the entirety of the property. Well, real estate agents are not always well versed in legal nuance. And so I've had situations where a spouse, unbeknownst to them, they had purchased the house as joint tenants, which is a completely different thing. So I always think that a very, very helpful, very approachable first step as far as this whole estate planning, because it's a long road of estate planning and it can go on until the time of your death. I think a very good first step is just looking at what assets you have, how they're currently titled, and then what beneficiary designations you have on them.
I have another question here, Will. What is a better option than adding someone to the bank account?
So that is a very good question. And I usually say add them as a co-signer, because a co-signer, they have the legal right to write checks. They can, set up auto payments. They can do everything that you would want them to be able to do. But upon your death, they do not become the sole owner of it. That would be a probate asset or it would be a trust asset, but it's not going to automatically vest all interest in them upon your passing.
Thank you.
Mhm. So wills versus trusts, kind of going back to the big picture of estate planning. So most people have heard or are familiar with a will, and I always, when I'm meeting with new clients, this is really my starting point as far as what our involvement in the planning looks like. So a will by its nature is essentially a document that says, this is where I want my property to go. This is my family information, and this is who I would like to administer my wishes. So the personal representative, sometimes it's called the testator or the testatrix for females. Really, that is the individual who would be charged with taking the will to the court upon your passing. And then they would kind of go through the legal process of ensuring that the court has all the documentation they need to then issue letters testamentary. And these letters testamentary are essentially what you would show to a bank, what you would show to a real estate agent, to anybody who would ask, hey, what right do you have to be parting with your mom's property, for example? So, one of the often overlooked aspects of a will is that a will, by its nature, has to go through probate. Just because you have a document that says, I want my property to go in such and such fashion, it does not automatically just happen, unfortunately. As nice as that would be, in Colorado, for example, we have a relatively easy probate process. I can usually get a personal representative approved in about a week's time, which is pretty good based on what I've seen across the U.S. Nonetheless, you're looking at anywhere from a $3,000 to $6,000 cost for the administration of the probate. By nature, Colorado requires that we leave a probate open for at least 6 months. So that means you kind of have this ongoing bookkeeping, this ongoing process of being subject to the whims of outsiders, as far as if there are creditors, if there are angry ex-spouses, angry family members, so on and so forth. And the real kicker for a lot of people when they find out that they're named personal representative is that if they do not diligently follow what you as the will creator set out, they can open themselves up to legal liability to anybody else who was named within the documents. So somebody plays a little fast and loose and they take a little extra off the top rather than, dividing it equally to their siblings, they can be sued for that, and they will most likely lose, because really the personal representative is a fiduciary role. And so they have certain requirements as far as how they have to conduct themselves in administering the estate and ensuring that the property is used in a manner in which you set forth through your will. So kind of just inadvertently hammered a lot of the cons of will planning, but Dave, did you have a question?
Yes. Does every estate go through probate?
Oh, that's a difficult. So every will, if there is any property that's not dealt with via beneficiary designation or via trust, then it is required to go through probate. So to give you an example, any real estate in Colorado that is not dealt with either through a trust or through a beneficiary designation, it is required to go through probate. And so there are certain situations where, and I believe every state pretty much has a what's known as a small estate requirement. But for example, in Colorado, if you pass away and you have less than $70,000 in assets, there's kind of a streamlined way for you to go through the probate process where you don't have to keep it open for 6 months and you don't have to go through the same time and the same costs as you would normally. But if the general nature of it is that if property is not dealt with either through beneficiary designation or through a trust, then it does have to go through probate. And so kind of a long-winded answer to a short question, but yes, that generally, any estate that is not dealt with through beneficiary designations or trust does have to go through a probate. And so with that, well, did that answer the question, Dave?
Yeah, I think so. Thanks.
Yeah, I
Okay.
believe so.
Okay, sorry, that's that was kind of a complicated one.
Well, and if the person who asked that needs more clarification, please go ahead and chat that in.
Sure. And so kind of moving on to the trust component. So a trust is essentially like setting up a bucket. So if I set up the buyer's family trust, then I'm really creating a legal entity that is separate of myself. And so what I will do is I will then put my assets into that bucket. So I will create a deed for my house, and I will put my house into the buyer's family trust. And then I will work with Dave and I will say, Dave, does it make sense to put these assets in right now? Or is it something that I should put in via beneficiary designation? And then, kind of making sure that everything is funneling through that trust, because if all of your property is in that bucket at the time of your death, then there's no need for a probate. You've essentially front loaded the probate process. And at that point, if my house is in the name of the buyer's family trust, then the terms within the buyer's family trust is going to dictate what happens to that property. And so to give you an example, if I put all my assets and my wife put all of our assets, we put both of our assets in this joint trust, this joint bucket. If something happens to me, then my wife really already has the ability to deal with any of my assets, to grab money from our joint brokerage accounts or from my individual brokerage account. If it's been moved into the trust, she can access all those assets, and all she needs to do is present a copy of the trust documentation to whoever it is that's holding the assets. Same thing upon my death. If we name our son as the successor trustee when both of us are gone, then all he would need to do to sell our home or to get rid of any of the assets is he would really just need to decide what he wants to do with them, look at the trust documentation, make sure that that's all kosher. And then he could go to a real estate agent and take the trust in and say, hey, I'm the successor trustee, I'm the beneficiary, I would like to put this house on the market. There's no need to go to a probate court or to get anybody else's approval for you to just kind of go ahead and start the probate process on your own. And then with that, you aren't, the other nice thing is that a will, at least in Colorado, is a public document. And so as soon as you file it with the court, it is free reign for anybody to come in and pick through all the nice little nuances of your family and see what's going on. And a trust is a private document. So the only people who would know what is going where and who's involved would be the people that I myself or my son as the successor trustee wants to know about it.
We have a few questions here. This one just came in, then I have a few other ones. How are personal property assets handled? Jewelry, furniture, automobiles, and such?
Sure. So we actually do an assignment within our trust documentation. And so we will actually assign all of the household goods to the trust as well. And that way, if they wanted to go and sell jewelry and, the jewelry emporium that's selling the stuff, they would say, okay, let's see the ownership records. You could then present the trust documentation that says, this was a part of the buyer's family trust. I'm now the successor trustee. I have the right to sell this property. Now, there are also personal property memorandums, which we include as well, that are essentially, they're kind of home done documents that say, I want my class ring to go to my son, Jim. I want my RV to go to, my sister, Susan. You can actually fill those out yourself and kind of change and rewrite those as you go, because if it's not a real estate or a financial asset, the states tend to not really care as much. I mean, that's kind of the reality of it. So all of those can be, immediately put into the trust just so that, everything's kind of in the bucket, but then you can deal with them separately through these personal property memorandums. And it's never going to inhibit your ability to sell property or get rid of property or do anything like that, because really, if it's not a part of the trust and if it's not there at the time of your death, then there's really nothing they can do. So.
Thank you. Another question came in. Who is the trust filed with?
So this is kind of a tough question because there used to be differing rules statewide, and ever since I want to say about 10 years ago was when the Uniform Trust Code first started to form, and more states are getting onto that. That really impacted where it was necessary to file a trust document with, because the reality of it is in Colorado, I don't really file trust documents with anybody. The only people that I file it with are people who are holding assets of the trust. So for example, my bank or my financial advisor, or, one example of, when you're asked, because again, it kind of goes back to the whole privacy point of a trust. And so they're really, I'm sorry, I just saw another good question pop up, but there isn't really anybody that you have to file it with right off the top of my head. Now it could vary from state to state, but as far as Colorado goes, the only people that have copies of the trust that involve my assets are going to be the people that I'm actively working with.
Okay, great. And I appreciate that. The other question here is, what if you own property in multiple states?
Then that makes it very easy for me to suggest a trust to you, because because I certainly have there are a lot of snowbirds in Colorado, and so frequently we will have people who they spend some time in Fort Collins, and they also have a place in Arizona or Texas or Florida. So what you really want to avoid is multiple. If you want to avoid a single probate, then you certainly want to avoid multiple probates. And so I have had situations where, and part of it is having a good attorney that you have a good relationship with, because truthfully, our kind of practice philosophy has been that those kind of questions, if I have a client come to me and say, hey, Will, I'm thinking about purchasing a property in Arizona, and I've set up a trust for them in Colorado. The first thing that I'm going to do is I'm going to ask them, do you have an attorney that you've worked with in Arizona? Because what we will want to do prior to purchasing the property, or if you've already purchased it prior to transferring the property into your trust, is we will want to have somebody, in Arizona or in Florida create a deed to the trust. And so usually we're paying an attorney, for an hour work in Florida just to have them prepare the deed. Then we get it filed in Florida, and all of a sudden that is a part of your trust estate. So you no longer have to worry about opening up a probate in Florida or Texas or Oklahoma or wherever it is. So really, if you have property in multiple states, that is an excellent reason to look at a trust as an option, because even if I'm based in Colorado, if I've done everything appropriately to have the property that I own in Florida moved into my trust, I don't have to worry about what's going to property overseas. So if you have property out of state, that's just an extra reason to have a trust, because as long as you get that property transferred into your trust, and that's a very common thing, something that a lot of attorneys are going to be very familiar with in their states. That's something that you are just not going to have to deal with probate regarding.
And beyond multiple states, what about property overseas? That's another good question that just came in.
Ooh, this is a good one, and this one is a little bit outside my pay level, but there are certainly, and honestly, I believe that my information will is on there, but that's something where I would certainly want to refer you to someone who is very specialized in that, because my only recent example is I've had to deal with some property in Nicaragua, and yeah, it's a bear. It is quite a bear, but if you can find somebody who kind of specializes in they deal with the Caymans, or they deal with Europe, or they are specific to Africa. It's amazing the amount of niches that there are in the legal realm. And so you can I know that you can do it. It's just going to look different based upon where the property is located. Mexico is actually a common one of ours, and to be quite honest, it's kind of the Wild West based upon the municipality of where the property is. So that is, as much as I would love to give you a little bit more definite answer on that, it varies so much from place to place. Now, that being said, if I were still starting from scratch and looking at what's going to give me the most tools in my toolbox as far as going forward, I'm always going to start with a trust if there's property out of the state or certainly overseas.
Are there any drawbacks to putting assets in a trust? For an example, is it harder to sell it or access it if they need it?
It's not harder to access it. Now, one hiccup, and I mean, with the way that interest rates are right now, it kind of gives the property owner the leverage, certainly. But one thing that I have noticed with individuals who have income producing properties is that if you have a mortgage on those properties, so there's actually a federal law. I'm blanking on the name of it, but there's a federal law in place that says if I transfer my main residence to a trust, and I have a mortgage on that property, the mortgage holder cannot alter the terms of our existing mortgage. So that applies for the principal residence. Now, if you have a rental property, for example, that you do have a mortgage on, usually what I suggest is just going to the mortgage holder and just saying, hey, we're updating our estate planning, and I would like to continue, paying you guys if you're okay with that, but I want to keep these terms the same. Most at this point in time are going to say, oh, okay, that's fine, because you can say, hey, if you don't want to allow this, then I'll find somebody else who will loan me the money. So really the only drawback is sometimes there's a little bit of legwork just in that regard, just ensuring that everybody's on the same page. But as far as selling a property, really the only difference is that you would be signing as trustee of your trust as opposed to yourself individually.
Another question here, does the trust require a notary?
Yes, it does. So a trust is almost always going to need to be notarized to be effective.
We're all caught up on questions.
Those are some good questions.
Great questions. Keep them coming in.
So again, we've kind of hit on this a little bit. The probate process, one of the big misconceptions, and I have had a lot of well-intentioned, intelligent people who get caught off guard by this. And the reality of it is if you have a will and your property says, I am going to leave it to this person, but the will is the only thing in place and there's no beneficiary deeds or anything else, then you're going to be required to open up a probate to deal with the assets. So again, it's not, it is very location specific. And so to give you an example, I generally do not allow probates to go longer than 6 months because everybody's circumstance is different. You want to be quick about it. You want to get the property distributed because somebody could be, they could be cash poor and need the assets. And so I really like to kind of hurry up and get things moving with the probate process. Now, California, and I hate to pick on California because it's an easy one to do for the probate process, but California, for example, I have spoken with many estate planning attorneys in California that I have a lot of faith in, and I certainly respect professionally. And they have basically moved to telling everybody who comes into their office, put your property in a trust, because the California probate process, on one hand, and this was a bit of an ethical surprise to me, but California law actually says that an attorney who's handling the probate. So I handle probates, and usually I just do them on a fixed fee basis. But in California, if you have $1 million house that is really the only probate asset that you need to get rid of, then the attorney who's handling the probate by law can take 5% of whatever the assets are involved in the probate. So you get to talking about, some of these $5-10 million estates, and that can get very expensive very quick and I say it's a bit of an ethical quandary to me because truthfully, you're paying exorbitantly more for the same amount of work. And so that's kind of one downfall of the probate process right there. I know Iowa, because I have family in Iowa, same thing exists there, where it doesn't matter what's involved. An attorney who's handling a probate can automatically take 5% of the probate assets for their fees. Additionally, it's usually about 2 years before you will get any progress in California if you're opening up a probate. And if there happens to be any California attorneys who are on this who can call me on that, I would welcome it, because a lot of this is I hear from secondhand, and I do not practice in California, but that's what I've been hearing from a lot of the professionals that I deal with out there. So yeah, it looks like there have been a couple of questions.
Yeah, why don't we go ahead and finish up your presentation, and we'll answer those during the question and answer section, if that's okay.
Sure.
Go ahead.
So, and then just to kind of wrap up the probate process. Again, the probate timeline, really you're looking at a minimum of 6 months. I've yet to hear anything shorter than 6 months. And truthfully, there are some probates that I've even had to handle that have gone beyond 3 years, just because of the nature of the assets and because of the complexity of what was going on. When in doubt, I say keep the courts out. That's kind of the less people involved, the less people looking into what is truthfully a very personal situation. I just think the better. Additional considerations. So this is another one that we could certainly spend a lot of time on. But so being in the elder law realm, as a lot of you may be familiar with, the current gift tax amount, or I always think of it as kind of a coupon that we each have as far as property that we can pass tax-free in life or at death. Currently, it sits at 11.7 million per individual. So, there are a lot of things going on tax-wise, and I would be remiss to not at least address that things could change, because we're always subject to change. But as it stands currently, there are not too many people who are brushing up against that, 20 plus million between a husband and a wife. Now, again, that could change, but really, as it pertains to this slide and what we're talking about, what we see as being the single largest, I guess, detractor from individuals' wealth and from family wealth is the long-term care component. So the most recent statistics that I've seen have said that at this point in time, about 1 in 2 Americans will need some sort of long-term care, which is pretty staggering when you think about the fact that, at least in Northern Colorado around here, I'm regularly getting quotes of $10,000 to $12,000 a month for a long-term care facility. So anybody gets $100,000 a year bill, that's going to get your attention. And so there is a lot of planning that we can provide within the documents, both in the financial powers of attorney and in the trust and the will documents, to provide for the ability to, look at least to have the tools available to potentially have Medicaid cover some of the bill, while also protecting your assets to ensure that they're going on to either your spouse or they're going on to your kids, because Medicaid is the federal program that pays for long-term care, and they have very stringent requirements about what you're allowed to have if they are footing the long-term care bill. And so that also kind of goes in line with special needs family members. We do a lot of work with families who have special needs children, special needs siblings, but very frequently Medicaid is in the picture when there are special needs involved, whether it's autism, whether it is a serious lifelong disability where somebody requires round the clock care. A lot of times and a lot of programs require Medicaid nowadays. So we look at that's where we're kind of getting a level deeper, as far as we're not just wanting to look at what happens when you die. We're also looking at, hey, how are these assets that you've worked so hard to preserve, how are these going to be used in the most efficient manner to improve the quality of life for your family members, but also to ensure that we're not throwing off anything that could be in the mix. I mean, I've certainly had situations where a family comes in and they have two kids who are adults and they're totally fine, but there's an MS diagnosis down the road. I mean, these are just the kind of things that we can't plan for. And so we really like to ensure that we have as many tools in the toolbox as possible to ensure that we're really shepherding those assets that you have to the people you want them to go to, and we're doing them in the most efficient and most effective way possible. So that's kind of the next level as far as getting into the weeds of some of the estate planning. But it's certainly something that if you do have those scenarios in your life, it's very helpful to at least have the talk with somebody about how you can best plan for those.
All right, let's take some time to take some more questions, and then we will round things out. David, I believe we have some more questions here.
We do. So there's one very detailed one and another that's a little more general. So I'll go with the general question here first. What if you opened a new bank account after the trust was created? Do you need to consult the attorney to update the existing trust?
So what you are talking about there is the broadly defined process of funding the trust. So that is something where what I do with all of my clients, after we've had kind of a couple months to work through the trust documentation and make sure that everything is the way that it's supposed to be, that's where I usually say, if you've opened up a new bank account, get me the contact info for your bank. Or, that's why I love using Dave as an example, is if I have a client who I know that they have accounts with Dave, or they recently opened up an account with Dave, as long as the client gives us the go ahead to talk amongst each other, that's where we can kind of handle it and talk about, okay, well, CT opened up this new bank account, and I can get on the phone with the bank representative and I can say, hey, we recently updated CT's estate plan, and we would like to ensure that all of the assets are going into the trust. Is this something that we can just change the titling to the bank account right away? And if not, I've seen credit unions, for example, they're not huge. Some of them are not huge fans of trusts, but what I can do in that situation is I can just update the beneficiary to be the trust. And so either way, you can still have that account. You can still use it just the way you would any other bank account. But at the end of the day, it's going to funnel into the trust, and there's not going to be anything additional needed to be done.
Okay, thank you. Can you talk a little about funding trusts with a payout from an insurance policy? Does that just happen with the beneficiary designation?
Yes and no. You absolutely can do that, and there are a lot of trusts that are. So actually, let me give you a good example of where I frequently use a life insurance policy to fund a trust. If I set up a special needs trust for an individual, because a daughter has Down syndrome, for example, and she's unable to manage her assets, but we want to ensure that she has the ability to have access to any Medicaid benefits. Excuse me. A lot of times, what I will do is I will talk about having a life insurance policy fund the special needs trust, and that's something where I can just go to the individual who handles the insurance policy. I can give them the information and say, it is the Susie Johnson Special Needs Trust. Here's when it was created, and this is what we need you to list as the beneficiary. So that's you can absolutely use life insurance policies very effectively in funding a trust. And if you just wanted it to go into the buyer's family trust, for example, then I could just go to my insurance company and say, hey, rather than having my spouse named as the primary beneficiary, I just want you to name the buyer's family trust as the primary beneficiary, and then everything kind of flows through that bucket.
Thank you. Another question here. Am I correct in thinking that in order to receive Medicaid assistance for long-term care, all assets of the married couple must be diminished before you can get Medicaid assistance funds?
You are correct in thinking that, but that is not the way that it actually works. So the good news is that, and I say this coming from the standpoint of someone who watched my entire grandmother and grandfather's estate depleted due to long-term care costs. If a husband and wife comes in to my office and we're doing this type of planning, we will actually provide within the documents. There are still certain above board ways to get assets out of your name, but also qualified for Medicaid. And so the general rule of thumb is that if let's say you're a couple in your 70s and one of you receives an early onset Alzheimer's diagnosis. If I've done your documents and we have everything up to speed and we have all the provisions in there that we need to address the Medicaid component, usually what we can do is we can actually protect about 75% of the assets and still get the spouse qualified for Medicaid. So there's some very high level financial planning that we can do in those scenarios. And you really aren't stuck basically impoverishing yourselves to get to that point, because it's a very common concern as far as that wealth spouse in the scenario going, if we're paying $150,000 a year for my husband's care, how am I going to go on paying for my day-to-day life that I need to? And so there are actually a lot of planning options available where you can get some of the assets out of your name, or at least out of your spouse's name, and still get qualified for Medicaid benefits. And
that's probably a topic for another webinar for sure.
We could spend hours just on that. But the good news is that as long as you have the ability to retain legal advice or retain me or retain a professional to do that sort of planning, you have options available.
I think we have time for one more question.
All right, I was just going to ask you that. And I think we made this a bit more generalized here. So can you talk about quit claim transfers? Say if a parent transfers a house to an adult child, does
Yes.
the parent have any say in the eventual sale and proceeds of the sale of the house?
So,
Oh, we asked you an easy one at the end here.
yeah. Well, I'm my lawyerly answer, which I know nobody wants to hear here, is going to be, boy, I would have a lot of follow-up questions on what exactly things looked like. But generally, where I tend to run into that issue is actually with Medicaid planning. And so the general crux of it is that once property has been transferred, unless there is some sort of postnuptial or prenuptial agreement among your wife's mother and the father, unless there's something in place indicating, hey, what we have in place today stands, and there is to be no outside transfers or anything like that, generally they cannot come back. Reason being is that if the property is in your name and there isn't some sort of contractual agreement left to fall back on, where, for example, the wife comes in or the mother comes in and says, hey, I did not agree to this. We had an agreement that said we were going to stand pat on everything that we had in our will. They're basically their claim is probably going to fall on deaf ears. So unless you fall into that realm of there being a postnuptial or prenuptial agreement, you're probably in the clear.
All right. Well, thank you so much. I know that if we haven't had a chance to answer your questions, please leave your phone number. We will reach out to you and connect you with someone who can answer that question. While I'm doing our outro, please go ahead and leave any more questions you would like. So thank you again on behalf of Advice Chaser. Thank you, Will. Thank you, Dave, for being here. We're so grateful for the organizations that have worked with us to bring you this webinar today. Thank you to our attendees for attending. Look for an email soon with a replay of this event, and you're welcome to share that replay with your friends and family. Here at Advice Chaser, we're all about helping you find a financial advisor who is a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Once again, from Advice Chaser, thank you so much for coming, and we will see you at another webinar soon. Goodbye, everyone.